Okay, so right now we're going to read the BARBRI criminal law outline, and we're in section 6, which is justification, but it's titled something a little different. Principles of exculpation. I can't say that word. Sadly. We're on page 43 talking about other offenses, particularly the mistake or ignorance of fact defense, and the general rule is that there isn't one. It is not a defense to a crime that the defendant was unaware that her acts were prohibited by the criminal law, or that she mistakenly believed that her acts were not prohibited. This is true even if her ignorance or mistake was reasonable. B. Mistake or ignorance of law may negate intent. If the mental state for a crime requires a certain belief concerning a collateral aspect of the law, ignorance or mistake as to that aspect of the law will negate the requisite state of mind. This situation involves ignorance of some aspect of the elements of a crime rather than the existence of the statute making the act criminal. Examples. A is charged with violating a statute prohibiting the sale of a pistol to one to be a convicted felon. A was unaware of the statute prohibiting this, but was aware that the person to whom the pistol was sold had been convicted of assault. A mistakenly believed, however, that assault was a misdemeanor. In fact, it was a felony. Is A guilty? Held no. A's ignorance of the statute prohibiting the sale does not affect her liability, but the statute requires awareness that the buyer was a convicted felon. Since A believed the buyer to be only convicted misdemeanant, she lacked the state of mind required for the crime. That's a good example. 2. B, who has had her car repossessed by a loan company, honestly believes she is still the lawful owner of the vehicle and is lawfully entitled to possession of it. She sees it sitting in a parking space in front of the loan company office and takes it. Even if B is wrong about her right to take the automobile, she's not guilty of larceny because she lacks the requisite intent to deprive another of his property. Exceptions. 1. Statute not reasonably available. 2. Reasonable reliance on statute or judicial decision. 3. Reasonable reliance on official interpretation or advice. 4. Compare. Reasonable reliance on advice of private counsel. And I think that would be it for the exceptions. Statute not reasonably available. The defendant has a defense if the statute prescribing her conduct was not published or made reasonably available prior to her conduct. And that was the case with the LA, Los Angeles statute where the felons were required to register with the city and couldn't prosecute someone for failure to act under the statute because it wasn't readily available, or at least it hadn't, the felon hadn't been notified of her responsibility to act, her duty to act. At least in my opinion, that's how that case read. 1, 2, reasonable reliance on statute or judicial decision. The defendant has a defense if she acted in reasonable reliance on a statute or judicial decision, even though the statute is later declared unconstitutional or the decision is overruled. The defense is strongest when the decision relied on was rendered by the highest court in the jurisdiction. 3. Reasonable reliance on official interpretation or advice. At common law, it was no defense that the defendant relied on an erroneous official statement of the law contained in the administrative order or grant or in an official interpretation by the public officer or body responsible for the interpretation, administration, or enforcement of the law. The emerging rule advocated by the MPC provides a defense when the statement is obtained from one charged by law with responsibility for the interpretation, administration, or enforcement of the law. Now, 4 is your comparison to the reasonable reliance that you placed on advice of a private counsel. So, unlike reasonable reliance on an official interpretation of the law, example, an opinion of an attorney general, relying on the advice of one's own counsel is normally not allowed as a true affirmative defense to a crime. If, however, the reliance on an attorney negates an otherwise necessary mental state element knowingly violating the law, such reliance can demonstrate that the government has not proved its case beyond reasonable doubt. Which is kind of like contradicting, but I guess that if you, it's possible to rely on advice of private counsel in bad faith, and getting that counsel's advice didn't actually negate your state of mind. Like, for instance, you didn't believe that your attorney was right, or maybe you asked them in such a way that their opinion was right, but you knew that the way in which you were going to go forward with your conduct was not, then your mental state was not actually reasonably clear of guilt, let's say. Anyways, where are we? Consent. May 3. And 3 under what? 3 just came out of the great blue. Okay. Consent is an other defense. So we talked about mistake or ignorance of fact. We've talked about mistake or ignorance of law. Now we're talking about consent. Okay, I get it now. Consent is that thing that happens before rape, kind of. Not really, but consent may negate an element of offense, and B, requirements of consent as a defense. So, A, may negate the element of offense. Consent of a victim is generally no defense. However, if it negates an element of the offense, consent is a complete defense. So your example is showing that the victim consented to intercourse is a defense to a charge of forcible rape, and 2, showing that an adult person consented to traveling with a defendant is a defense to kidnapping. Really, it is? Okay. Well, for some crimes, the consent of a victim is of no relevance. For example, consent of a victim of statutory rape has no legal significance. For other offenses, consent may be of limited effect. For example, within limits, a victim may consent to infliction of physical violence, and one inflicting it will therefore not be guilty of assault or battery. And you see the cases that in, like, say, like football, if you're going to go into a rock climbing or something like that, and you sign a waiver, and that will negate an element for, say, the other football player that tackles you too rough and injures you. They're not going to be found guilty of a criminal offense. However, the purpose of playing football is an exhibition sport, or one for skill or for recreation, so there's a purpose to it. It would be different for you to consent to physical violence if there was no reasonable purpose for it besides that of giving the consent, in which case you can't just give consent for someone to just stab you or to kill you. That's not a defense. So requirements of consent as a defense. Whenever consent may be a defense, it must be established that 1, the consent was voluntary and freely given without compulsion or duress, and 2, the party was legally capable of consenting, which I think makes the kidnapping defense kind of hard to believe, because I feel that that individual has to be a kid, i.e. an infant, that is not legally capable of consenting, but nevertheless. Third, no fraud was involved in obtaining the consent. And as I said before, fourth, there has to be some kind of like purpose. If the consent is going to be with regards to physical violence, there has to be something in it for the person giving a consent. Anyway, 4, condemnation by injured party, no defense. Forgiveness by the injured party after the crime has been committed ordinarily does not operate as a defense to the commission of a crime unless the statute establishes such a defense. For example, forgiveness of by an assault victim would not bar criminal prosecution of the perpetrator. Compare, some statutes provide that marriage of the parties will bar prosecution for seduction. Okay, 5. Criminality of victim, no defense. The nearly universal rule is that illegal conduct by a victim of a crime is no defense. For example, A, knowing that B has amassed a fortune through illegal gambling, defrauds B in a real estate deal. Does B's unlawful gambling activity provide A with a defense to fraud? And the answer is no. So you're not allowed to just go to El Chapo and like make him a false, fraudulent loan in order to take his house in Mexico, because you're still guilty of fraud, even though he's a drug warlord. Okay, anyway, 6, entrapment. Entrapment occurs if the intent to commit the crime originated not with the defendant, but rather with the creative activities of law enforcement officers. If this is the case, it is presumed that the legislator did not intend to cover the conduct, and so it is not criminal. The defense of entrapment consists of 2 elements. Romanet 1, the criminal design must have originated with law enforcement officers, and Romanet 2, the defense must not have been predisposed to commit a crime prior to the initial contact by the government. If the defendant offers credible evidence on these 2 elements, in most jurisdictions, the government must then show predisposition beyond a reasonable doubt. And okay, so we've got quite a bit of stuff here under that statement. A, B, C, D, E, F. And that's going to be it for this section. So let's get through it, even though it's relatively not that important to talk about entrapment before this exam. Nevertheless, A, offering opportunity to commit crime distinguished. B, inapplicable to private inducements. And C, availability of offense denied. D, practical difficulties of entrapment. E, minority rule, objective test. And F, provision of material for crime by government agent, not entrapment. Quickly, A, offering opportunity to commit crime distinguished. It is not entrapment if the police officer merely provides the opportunity for a commission of a crime by one otherwise ready and willing to commit it. Example, A, an undercover police agent poses as a narcotics addict in need of a fix. B, sells narcotics to A. Does B have the defense of entrapment? No. By posing as an addict and merely provided an opportunity for B to commit the criminal sale. B, inapplicable to private inducements. A person cannot be entrapped by a private citizen. Inducement constitutes entrapment only performed by an officer of the government or one working for him or under his control or direction. C, availability if offense denied. If a defendant denies her participation in the offense, she has elected not to pursue entrapment and is not entitled to raise the issue, even if the facts would otherwise permit her to do so. Under the modern trend, however, a defendant may raise a defense of entrapment even while denying participation in the offense. The Supreme Court has adopted this rule for federal offenses. That's like a really complicated concept. A defendant may raise a defense of entrapment even while denying participation in the offense. D. Practical difficulties of entrapment. In cases where there is an extended inducement by the government, the issue becomes whether the defendant was predisposed to commit the offense or whether the intent to commit it was instilled by the officers. Predisposition must exist prior to the government's initial contact with the defendant. A mere inclination to engage in the illegal activity is not adequate proof of predisposition. However, even if predisposition is not proved, the introduction by the prosecution of potentially damaging evidence on the issue of the defendant's predisposition may cause a jury to convict on the basis of the extensive evidence of the defendant's culpable state of mind. Minority rule objective test. This is E. The minority rule would replace the entrapment elements set out above with a test based entirely on the nature of the police activity. Under this test, a defendant would be entitled to acquittal if the police activity was reasonably likely to cause an innocent, unpredisposed person to commit the crime. The defendant's innocence or predisposition is irrelevant. Under this approach, the issue is decided by the judge rather than the jury. An F. Provision of material for crime by government agent, not entrapment. The Supreme Court has held that under federal law, an entrapment defense cannot be based solely upon the fact that a government agent provided material for commission of the crime, even if the material provided was contraband. A few states, however, make the provision of essential materials, such as ingredients for drugs, to the drugs themselves entrapment. Now, we're going to move into Section 7, Offenses Against the Person. And since this is on page 47, and 47 to end is where we're going to talk about the crimes themselves, the substantive crimes themselves, not any principles or levels of culpability or defenses or justification. I'm going to stop here and start with a new recording.